My Lord the Chief Justice, my Lady the Deputy Chief Justice, and judges of the Supreme Court. For the record, I'm Ignatius Muhatia. As intimated by my learned friend, I'll be laying the factual background as affected our client prior to the 26th presidential election. Suffice to notice that the first interested party, my Lord, was a presidential candidate in the general elections held on the 8th of August 2017, having been duly nominated by his political party, the Third Way Alliance Kenya, and cleared by the first and second respondents. After the disputed elections, a petition was filed, being petition number 1 of 2017. Our client applied for enjoyment, and he was granted the right for enjoyment. However, when the court nullified the August general elections and ordered for repeat presidential elections, the first and the second interested parties unlawfully and unjustifiably excluded the first interested party from taking part in those repeat elections, out of sheer determination to ensure that his rights as guaranteed under Article 27 and 38 of the Constitution were respected. The first interested party, via a notice of motion dated 6th of September 2017, sought the intervention of this court for clarification on the meaning and effect of fresh elections under Article 140, Sub-Article 3, pursuant to this court's determination of 1st September. However, this court, via a ruling made on 21st of September, declined to admit the matter for hearing on account of jurisdiction and made orders referring the first interested party to the High Court on account that the sought clarification sought an interpretation of the Constitution, a jurisdiction this court did not have. Further, our client filed a constitutional petition number 471 pursuant to that court order in the High Court. And on the 11th of, suffice to note that some of the issues that were determined in these petitions related to the nomination of presidential candidates in the repeat presidential elections, as well as an interpretation of the meaning and effect of fresh elections under Article 140, Sub-Article 3, as well as an interpretation of Article 138(5), my lords. Via a judgment dated 11th of October 2017, the High Court upheld the rights of our client and ordered the first and second respondents to include him as a presidential candidate in the repeat presidential elections. Upon that, our client sought information from the first and second respondents on the measures taken to include his name, as well as those that were intended or taken by the first and second respondents to ensure that the irregularities and illegalities that were witnessed and cited in the judgment of this court in nullification of the elections were addressed. And that is via a letter dated 12th of October 2017, and I refer you to the paragraph 19 to 26 of the affidavit of Dr. Aukot, dated 15th of November 2017, my lords. We have annexed thereto the decision of this court, the ruling referring us to High Court for interpretation of the Constitution on the aforesaid issues, as well as the letter to the first and second respondents seeking a clarification of the said issues. In response to that, the first and second respondents invited the first interested party for a meeting at the IBC offices, where they deliberated upon the various issues that affected the nullified elections and how they sought to redress the same. A copy of the said, during those discussions, the first and second respondents shared a report on the mechanisms that they had actually undertaken to redress those irregularities and illegalities. We have annexed thereto the petition to the affidavit, the report marked EA3. My Lord, suffice to note that in our submissions, we shall be establishing grounds to show that the petitions herein were not actually brought in good faith and with clean hands. This is the fact that, as intimated by Dr. Aukot in paragraph 3 of the replying affidavit, there is a pending appeal on the issues that this court referred us to High Court for determination, and a fact that the petitioners deliberately refused to disclose to this court in the petition. On that account, I will invite my learned friend, Mr. Mutuma, to take us through our submissions and authorities that we shall rely on in our response to the petition. I thank you, my lords.